Good morning. I see Mr. Watson is here and Mr. Stevens.
Morning, Judge.
Good morning. Mr. Gardenhire, can you hear us?
Yeah, I can hear you.
Okay. On the record in the matter of the people of the state of Michigan versus Isaiah Gardenhire, file number is 21-02191FY. Can I have your appearances, counsel?
Andrew Stevens on behalf of the people.
Your Honor, good morning. Keith Watson on behalf of Mr. Gardenhire. He's present remotely from the Isabella Jail.
Thank you. Today's the date set for preliminary examination. My understanding is that there's going to be a waiver of the 21-day timeline. Is that accurate?
Yes, Your Honor, and I will defer to Mr. Watson to further explain the circumstance regarding this.
It is accurate. Your Honor, I had a COVID exposure, which caused me this last Sunday to have to go in and get a test. I fully expected that based on how it is I was feeling and based on as well my having to await a PCR and clearance as according to the county rules as it relates to COVID exposures. I fully expected that I would be unavailable to appear today corporeally to conduct the examination. So I thought I was being responsible when I did this 2 days ago now, contacting Mr. Stevens and contacting other assistant prosecuting attorneys with whom I had to work to advise them of this. And then wouldn't you know, just yesterday, I received my PCR clearance. So as a result of that, I appear remotely today, hat in hand, expressing to Your Honor that I did this out of caution for public safety.
Thank you. Okay, so we appreciate your caution and not coming here after being exposed to the COVID-19 virus. So what we will do here is Mr. Gardenhire, can you hear me?
Yeah, I can hear you.
Okay, so due to your attorney's explanation of his potential exposure to COVID-19, he was unable to appear in person today. So you have a constitutional right to have a preliminary examination here in the district court within 21 days of your arraignment. However, due to that exposure, your attorney is seeking to extend that date so that we can set it for a new date so he can safely enter the building and safely interact with you and other members of the court so that he can facilitate the examination. So are you willing to waive your 21-day timeline for that purpose, sir?
Yes, ma'am.
I'm sorry, I didn't hear you.
You said you can't go on wave? What?
I'm not making out what you're saying. You don't want to waive the 21 days?
Yeah, I'll wait the 21 days.
Okay, so we'll set it for a new court date and then you'll be readied over for your exam at that time, okay?
Okay.
Does November 4th at 8:30 work?
Your Honor, it does not work for me. I'm scheduled to begin a trial in Judge Kennedy's courtroom next week, in fact, a week from today. The trial schedule with Judge Kennedy is as follows. October 21st and 22nd, followed by October 25th and 26th. Judge Kennedy is then off until the first week of November. So that would be November 1st, 2nd, 4th, and 5th. In fact, we anticipate that the trial may actually go into the second full week of November. That would be November 8th and 9th. The trial is a homicide trial involving the death of a baby. There is significant, the people have a significant witness list, which includes a number of expert witnesses, and there will also be expert witnesses from the defense standpoint. So, and this is something I detailed to Mr. Watson coming into today's date. So from the people's perspective, I don't anticipate becoming clear of that case until probably the third full week of November.
Okay, what's the next date you have to know? So November 18th, does that work? At 8:30?
I believe based on that timeline and that trial that I can make that work.
Mr. Watson, does that work for your timeline?
Does, Your Honor, I've got my calendar before me at 8:30 on the 18th of November.
That's correct.
I'll mark my book. Thank you.
Okay, this matter will be adjourned until then. Any additional matters for the record?
Nothing from the people. Thank you.
Nothing further from the defense. Thank you.
Thank you. You're all set for today, Mr. Gardenhire.
Good, thank you.
Mr. Keithley, are you ready on Mr. Regan?
I am, Your Honor.
So on the record in the matter, the people of the state of Michigan versus Christopher Michael Regan. File number is 21-01764 FY, counsel appearance.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Christopher Regan, who is present via Zoom.
Thank you. Today is the date set for a sentencing. The court has a pre-sentence report and recommendation. You got a copy of that, correct, Mr. Keithley?
I did, Your Honor. I've also gone over it with Mr. Regan. We have no additions or corrections to the report.
Okay. Do you want to address the court prior to sentencing?
Thank you, Your Honor. Based on both my contacts with Mr. Regan and the information contained in the report, I believe Mr. Regan is an individual who's going to be successful on probation. He seems to have very limited criminal history. Additionally, he's been stably employed throughout his time while this case was pending. He's appeared for all of his hearings and he's basically been ready to go. He's taken accountability for his actions here. And I would also note that the behavior that brought him before the court today is, at this point, over a year old. He hasn't had, as I understand it, any bond violations. As the courtroom may remember, he was on a misdemeanor case that was pending for quite some time. And then this case sort of dropped late, even though it actually occurred on the same date in July of 2020. Based on all of that, we would be requesting that the court adopt the recommendation and sentence Mr. Regan to a probationary term with 7411 status.
Okay, Mr. Regan, you don't need to make your own statement because your attorney is here to advocate for you, but to the extent that you wanted to say something before the court sentence you, you can do so at this time.
No, thanks, Your Honor.
Okay. The court's had an opportunity to review the pre-sentence report and the recommendation. I've also reviewed your prior criminal history. You pled guilty to an added count to a controlled substance use with a sentencing agreement of 7411. The court will adopt the recommendation of probation. You will be granted 7411 status. The term of probation will be for 9 months. While on probation, there's a $30 per month oversight fee that you will be responsible for. Okay, sir?
Yes, ma'am.
You're not to use, purchase, or possess alcohol, marijuana, or a controlled substance without a prescription unless you have a prescription while on probation. Okay, sir?
Okay.
You're going to be required to submit to random PBTs and/or urinalysis, and you have to pay the fees directed.
Okay.
And then you're going to need to participate in some mental health services, okay?
Okay.
Are you currently employed still?
Yes.
Okay. You're going to be required to maintain your employment while on probation. You're not to be at any bars or nightclubs. You're not to
Okay.
purchase or possess firearm, ammunition, or weapons of any kind during that probationary period. Okay, sir? Do
Okay.
you have any questions about the terms of your probation at this time?
No.
Okay. As to fines and costs, there's a $75 crime victim rights fee that will be assessed. There will also be a $50 state minimum cost assessed. Probation for 9 months will total to $270. I'll waive any discretionary fines and costs at this time. Your total will be $395. You'll make monthly payments on that, okay, sir?
Okay.
If you were here in person, you would receive this advice of rights for probation. It says that you have the right to request a hearing for early discharge from probation once you have completed half the original term ordered by the judge. You must file a motion for early termination of probation with the court. You cannot request a hearing for early discharge until all rehabilitative requirements have been completed and there has been no probation violations within the 90 days preceding your request. You have the right to hire or retain an attorney to represent you for that hearing for early termination of probation, but you do not have the right to court-appointed counsel to represent you for that hearing. If you are on probation for domestic violence, stalking, criminal sex crimes, human trafficking violations, or an offense where the defense was asserted of guilty but mentally ill, you are not eligible for early discharge from probation. Do you understand those rights, sir?
Yes.
Okay, do you have any questions today?
I was just wondering about the so the drops, like how often and how much it's gonna cost. Just so I can kind of tally up the whole thing.
Probation will go over that. They're gonna contact you to go over your judgment of sentence, but the first time you're ordered to drop, there's, I think, a registration fee that you'll be responsible for, and I think it's about $90. I could be wrong. And then after that, it should be about $11 to drop, depending on where you're dropping. Mr. Keithley, is that accurate?
Honestly, Your Honor, I do not know off the top of my head.
Right. Probation department will be the best person to explain that to you about the cost associated, but I think that the figures I gave are a ballpark figure of what you should expect each time that you're dropping. You should be expecting to drop right now at least once a month.
Okay.
Do you have any other questions?
No, I don't.
Okay, any additional matters for the record?
No, Your Honor, thank you.
You're all set for today, Mr. Regan.
Thank you.
Thank you. Okay. Mr. Milks and Mrs. is it Alicia Bernard? Okay, are you on that one?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Elisa Bernard. File number is 20-0448FY. Council appearance, please.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Ms. Bernard, both of us present via Zoom today, waiving our in-court appearance.
Thank you. Today's the date set for preliminary examination. I have a note here that there's a request to adjourn.
Yes, Your Honor, that's correct. If Your Honor may recall, this matter was last up before the court on September 16th of this year. At that time, Mr. Milks had just been retained and the court granted an adjournment of the PCC and PE. Additionally, at that time, Your Honor, there was an outstanding discovery matter. There was a photo lineup that was conducted after the charges were issued, and the parties were waiting on a report of that photo lineup. The parties do not have that at this time. I do know that it's taken some time. I will advise the court, and I advised Mr. Milks yesterday, that the detective on the matter who conducted that lineup was gone from the dates of September 18th, just after this, until October 4th. That may or may not be playing into why we do not have a report yet, but I have looked into the matter. I have nothing to provide at this time. And with that in mind, Your Honor, both parties, I believe, are in agreement that an adjournment would be appropriate for that pending discovery.
Sounds good. Mr. Milk, that's accurate. You are requesting an adjournment as well, correct?
That is correct, Your Honor. We are requesting an adjournment at this time. Thank you.
Okay, we'll set this a few weeks out to allow some time for the detective to possibly catch up and get that discovery for your review.
Thank you, Your Honor.
Problem. He's not here.
We can do November 4th at 8:30.
Does November 4th work for you, Mr. Milks?
I'm sorry, what was that, Your Honor?
November 4th at 8:30?
That'd be perfect, Your Honor. Thank you.
It is that, Your Honor, originally, Your Honor had set both a PCC and a PE because we have not had a PCC since Mr. Milks was retained.
Okay.
So is that the PCC date or PE, Your Honor?
We'll set that as a PCC date, and then we'll do the PE the following week if that works for you, Mr. Milks.
Yes, Your Honor, that should work.
Okay, so the PE will be November. Oh, wait. That's a holiday.
Yeah.
Well, you can do the PE after that, a week or so. Well, what day are we doing PE? So, actually, I think I took the 12th off.
Friday.
I took the 12th off though, so we can do the 18th. Does that work for you, Mr. Milks? For the exam on the 18th?
I'm sorry, Your Honor. I'm out of town at that time for my sister's wedding.
Okay. Let's see. The 11th is a holiday, and I took the 12th off. So we'll do the 25th. No, because that's Thanksgiving. We're doing exams on the 24th, though, I think, right? It should have been. Okay. The holiday.
No.
Yes, for Thanksgiving. 24th is March. Wonder why that's off.
There's no other evidence.
You know where I go.
No, I agree. I agree about summer. This summer. Yeah. But we've been together for about 6 years. But I had a house. One and stuff, and she had a room and 4 rooms. Put it all in the same house. No, I so she really bought for the land. Yeah. Special. It was a building in 1970. It seemed to be right when it started cutting a lot of corners of, construction, technique and materials. So it's reaching the point where.
Your Honor, I'm sorry. I can't hear anything at this point. I don't know if.
Fix it up and do some renovations.
Oh, sorry, I think I muted us.
Oh,
Can you do the 24th of November, either of you? Because I know that's the day before Thanksgiving.
yes, Your Honor, I will make that work.
Okay. We'll schedule it for 8:30 at this point. We'll figure out why they blocked the calendar. Administration blocked it because they didn't want someone putting things on. Okay, so we'll do 8:30 on November 24th for the preliminary examination.
Very good. Thank you, Your Honor.
No problem. Any additional matters for the record?
Nothing for the people, thank you.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set, Ms. Bernard. Who do we have here? We're on the record in the matter of the people of the state of Michigan versus Kendrick Ramon Harrington. File number is 21-02683FY. Council appearance, please.
Thank you, Your Honor. Good morning, Aaron Housefield on behalf of the people.
And Charles Petrovich on behalf of Mr. Harrington, who's present to my right.
Today's the date except for preliminary examination. There's also a PA 53 hearing scheduled for today. How do we want to proceed?
Thank you, Your Honor. I will let Mr. Petrovich answer as to the PA 53, but with regards to the preliminary examination, the people are asking for an adjournment of this matter. I learned on the 12th, which was Tuesday of this week, that the victim in this case was having COVID-like symptoms and had a test scheduled for today, but in the meantime was going to be seeking treatment for COVID. I reached out to Mr. Petrovich to advise him of that and request an adjournment. It's my understanding that his client was not willing to stipulate to that adjournment, but given the safety concern for the public, having a victim appear when she's presenting with symptoms and not yet able to test, I believe, Your Honor, would be a basis for good cause adjournment.
Mr. Petrovich.
Yes, Your Honor, that was a full and accurate statement. I discussed consent to an adjournment with Mr. Harrington prior to today and confirmed the plan of action while we were speaking prior to court this morning. So we do oppose the adjournment. Mr. Harrington does have the right to have his preliminary examination within the time frame for this. I do understand the circumstances of the prosecution, so I'll leave it to the court whether you'll find good cause.
You said you received the call on the 12th, which is 2 days ago. This police report, or that the allegations are accurate, then you would have been exposed as well to COVID. I'm going to find good cause to adjourn this matter based on the possible exposure to COVID. I'm going to make sure that the jail is aware that you need to be tested. Okay? Sorry, the fourth. The fourth, what is today? The fourth is about 2 weeks out. I think it was the 18th. I'm inclined to believe we can't proceed on the PA53 either because it's the same.
Your Honor, with regards to the PA 53, due to the facts of the case and discussing that with Mr. Harrington, he is prepared to admit to that this morning without a hearing.
Okay. Okay, so would adjourning this matter to November 18th be okay with your schedule?
Yes, it would.
Fine for the people, thank you.
Okay, we'll adjourn the preliminary examination till November 18th at 9 a.m. Okay, and then as to the PA 53 violation, Mr. Harrington, that's accurate. You would like to plead guilty to that?
Yes, ma'am.
Do you raise your right hand? You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. And can you help him pull that mask up over his mouth, please? Thank you. Nope. Okay, so Mr. Harrington, I have here a police report dated October 10th, 2021 at approximately 06 hours. Officers were dispatched, it says, to the address of 5923 Southbridge Boulevard. The allegations that you violated your no contact order by being in direct communication with the alleged victim. Amethyst Bartlett.
Yes, ma'am.
And so as to that allegation, you are willing to plead guilty to that today? Because I can't hear you. So you're pleading guilty?
Yes, ma'am.
Okay. So you were originally arraigned on the underlying matter on September 27, 2021 by the magistrate Laura Melmore, and there was a no contact order issued. Is that correct?
Yes, ma'am.
So you were advised that you were not to be within 1,500 feet of wherever Amethyst Bartlett live, works, or go to school. Is that accurate?
Yes, ma'am.
Okay, and so on October 10th, did you violate that order?
Yes, ma'am.
Okay, and what did you do to violate that order?
Her son called me and said that she hasn't moved or was slightly breathing that day. And I asked him if he call the police or call EMS. He said his mother said no to it. I went over to see if she was breathing, if she was alive. She was barely breathing. I gave her, I resuscitated her, a little CPR, compressions on the chest, and she took a deep breath and asked me why is this happening to her. From there, took her to the shower and got in the shower with her and helped revive her. And from there, she started breathing better and everything was fine, but I was under the impression that she was dying.
Okay, but you knew at the time that you were in violation of your no contact order when you went over there?
Yes, ma'am.
Did you ever call 911 for medical assistance for her?
No, I did not.
Okay. Any additional factual basis?
No, Your Honor, thank you. The people are satisfied.
You satisfied?
No, I'm satisfied as well, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea if I have to be made to you voluntarily and intelligently. You feel as if you were taken into custody at that time, is that correct?
Yes, ma'am.
Okay. Mr. Petrovich, do you want to address the court before I sentence?
Yes, Your Honor. This is a situation, you just heard the factual circumstances surrounding that. Mr. Harrington does understand that even though it was, as he described it, a medical emergency, that he should have called 911 and allowed that to be regardless of whether her son wanted to call 911 or not. He is taking full responsibility for his actions on that night. I would note that there is no allegation that there was any assaultive contact, including in the report that came along with the PA 53 for that. And while I completely and thoroughly understand, as I think Your Honor knows I understand, that is not Ms. Bartlett's choice as to whether there is no contact order. Her statements as well that are contained in that report reflect that I don't believe that she wants the no contact order in place for this. It's a situation that's confusing for individuals who are facing these kinds of charges for the first time. I reviewed Mr. Harrington's criminal record, and he's never had a domestic violence. He's never had a situation where he's no contact with someone who's so close to him. So he does fully admit he's wrong for this. I don't believe it is a blatant wrong. I don't think he was intending to thumb his nose at the court. I think he was reacting to a situation that was quickly developing and is now taking full responsibility for that. So I'd ask you to consider that in imposing the sentence for the violation.
custody since the 5th. I'm sorry, since the 10th. Okay, Mr. Harrington, I understand the factual basis that you outlined to the court or the reasons why you state you violated your no contact order. The no contact order doesn't give you an exemption if there's a medical emergency. You understand that?
Yes, ma'am.
If you believe there to be a medical emergency, you can call 911 and have them report. But you don't get to be within 1,500 feet of wherever she lives, works, or goes to school. Do you understand that?
Yes, ma'am. I was scared.
I recognize that, but are you a medical professional?
No, ma'am, I'm not.
Okay, do you have any medical training?
CPR
Okay, you're certified in CPR?
way back in high school.
Okay, so then you're not currently certified in CPR. And even if you were certified, even if you were a doctor at this point, there's still no contact order. Do you understand that?
Yes, ma'am.
Okay, so for your future reference, if that happens and you become scared, you call 911 and say that they need to go check on her welfare, not you go check on her welfare. You understand that?
Yes, ma'am.
Okay, I'm gonna sentence you to time served. You need to go get a COVID test, sir. Any additional matters for the record?
Nothing for the people, thank you.
For the defense, I do have a question clarifying Mr. Harrington's bond. When he was arraigned on the 10th for the PA 53 violation, Judge Buchanan set a $50,000 cash surety bond. My understanding is that that applies to him being held for that violation. So I just want to clarify whether now that that has been resolved with his original bond prior to that, it's going back into
That's the
effect.
12,000, not 50,000.
Oh, sorry, I'm confusing him with another case. Sorry. That was a bad arraignment day. There were a lot of high
No
numbers.
problem. Yes, we will convert his bond back to 5,000 personal recognizance and reiterate again a no contact order as to the alleged victim, okay? Any additional matters for the record?
No, Your Honor, thank you.
Nothing further. Your Honor. So, that's the other cases.
And Mr. Abbott, how are you?
I'm well, Your Honor. I'm representing Dimitri Jackson this morning. People are represented by the Attorney General.
He's not logged in, or is he in person?
The Attorney General, Mr. Hayes, is right here.
I mean, Mr. Jackson.
Mr. Jackson is in the hallway.
Oh, he's here in person.
He's
Okay.
going to waive his preliminary exam, Your Honor.
Okay. Is he no longer in the, is he with MDLC?
He is, Your Honor.
Well, he can come in.
Your Honor, I will go check on the status of witnesses for Trevino, which is the one that is expected to run
Okay,
while the court does the AG case, if that's okay.
sounds good.
Thank you.
Common. That's true. This is common, huh?
I don't know, that is APA Chris Martin, Your Honor.
Okay.
I
Okay,
can
I
find
see
out.
him. Okay.
And I know there's conflict counsel on that now. I don't recall who it is. You have
I see
an update?
Carter on here.
Okay,
Okay, Mr. Goodrich. Devoya Martinez, I guess, is in custody.
Yes.
Okay, I guess Mr. Bigelow is gonna bring
and that's complete, Your Honor.
that person.
Okay, very good.
Hi, how are you?
I'll go ahead. No worries.
Do you need to speak to him?
No, Your Honor, I already did.
On the record, in the matter of the people of the state of Michigan versus Dimitri Moses Jackson, the file number is 21-01676 FY. Can I have your appearances, counsel?
Good morning, Your Honor. Robert Hayes, Assistant Attorney General here for the people.
Good morning, Your Honor. John Abbott, representing Mr. Jackson. He is present and seated to my right in the jury box.
Thank you. How are you today, Mr. Jackson? Doing good. Okay, today's the date that was set for your preliminary examination, and Mr. Abbott, you said there was going to be a waiver?
That's correct, Your Honor.
Okay. Other people waiving as well?
Yes, Your Honor, thank you.
Mr. Jackson, you understand you have the constitutional right to have a preliminary examination here in the district court?
Yes, ma'am.
You understand that at the time of the examination, you have the right to have the people bring sufficient evidence to establish their burden of probable cause. So that's probable cause that a crime was committed and probable cause to charge you with that crime. You understand that?
Yes, ma'am.
You want to waive that unconditionally today?
Yes, ma'am.
So unconditionally meaning you can't come back later and say you didn't know or you changed your mind, you want to have it.
Yes.
Once you waive it, it's gone. This matter will be bound over to the circuit court for your trial. You understand that?
Yes, ma'am.
Was there an offer extended at all?
Your Honor, there has been. People are offering Mr. Watkins to plead to one count of identity theft, which is a 5-year felony, and one count of unemployment fraud. I think it's 1,020, which again is the 1-year misdemeanor.
One count identity theft and one count of
Unemployment fraud.
Mr. Abbott?
It should also include in that the description of the offer that he would dismiss the remaining counts in the habitual.
That's accurate, Your Honor.
We had a co-defendant on this, didn't we?
Your Honor, we did. Ms. Griffin, Devon Griffin is the co-defendant. She has waived her preliminary exam and has been bound over.
Okay.
I don't believe there's a date set at this time in circuit court.
Okay, so she waived transfer. Okay, fine, your waiver to be made freely and voluntarily. I will bind this matter over to the circuit court for further proceedings. It is the 13th. Not the 14th. Bind over the 27th. Bind over is the 27th. That's the 27th. Sounds good.
Yeah.
Your bind over date's gonna be October 27th. You do not need to appear in court on that date. That's the date they'll get the file from this court. Once they receive this file, they'll set your next court date, which will be a pretrial. Your attorney will be made aware. You'll be notified. How long are you gonna be, oh, I have a note here, you'll be in the custody of MDOC into 2023, is that correct?
Yes, ma'am.
What facility?
St. Louis Correctional Facility.
Okay, we'll make sure you're ready for your next court date. Any additional matters for the record?
No, Your Honor, thank you.
Nothing from the defense, Your Honor. Thank you.
Okay, you're all set.
Thank you, Your Honor. Have a good day.
Thank you.
Good to see you again, Mr. Bennett.
well, the record in the matter of the people of the state of Michigan versus Beatrice DeMoya Martinez. File number is 21-018880FY. Can I have the appearances, please?
Thank you, Your Honor. Aaron Housfield on behalf of the people.
And Luke Goodrich from the Public Defender's Office here to represent Ms. Moya Martinez, who's standing to my right.
Thank you. How are you today, Mr. Moya Martinez?
I'm fine.
Today's the date that was set for preliminary examination. However, I have a note that there's going to be a plea. Is that accurate?
Yes,
That
it-
is.
Yes,
Can
it is, Your
you
Honor.
place the offer on the record?
Yes, Your Honor, thank you. And just before we get started, I advise the court that this matter was also going to take into consideration a misdemeanor file, 21-02116 SM. Was that pulled?
It was it?
The trace. Next to her.
21-.
02116 SM, Your Honor. Thank you. So in file number 21-01880FY, the felony matter, Your Honor, the defendant is going to plead guilty to an added count 2 of aggravated assault pursuant to 750.81A. The maximum penalty on that, Your Honor, is 1 year and/or $1,000. In consideration for that plea, the people will move to dismiss count 1. There's also a Killebrew agreement, Your Honor, to a term of probation, and the people would be making a recommendation to this court that the defendant be screened for substance abuse and/or mental health treatment and follow all treatment recommendations. In the misdemeanor file 21-02116 SM, Your Honor, the people will be entering a nollie. There is an agreement that the defendant will pay restitution in the amount of $200 to the victim in the misdemeanor case, and I have a restitution form for the court.
And Mr. Goodrich, that's a complete and accurate understanding of the plea offer?
Yes, it is, Your Honor. And just to further clarify, it was to be a no contest plea as well due to the lack of memory of the defendant.
My apologies, Your Honor, that is correct. Mr. Goodrich supplied it to the court yesterday, Your Honor.
Your client is in the waiting. I have file number ending in 21-02116 now. There's already a non attached. And then I also have a police report. And so, Ms. DeMoya Martinez, that's the offer that you recall being offered to you?
Yes, Liz,
And you wish to accept that offer by pleading no contest today?
I do.
Okay. And it's your position that you don't have a recollection or a memory of this?
I don't remember it.
Were you on the influence at all during this time?
Yes.
Okay. As to the added count 2 of aggravated assault, how do you plead, ma'am?
No contest.
Okay. Anybody making any threats or promises to you to get you to plead no contest today?
No.
Okay. I have a police report here dated for June 9, 2021 at 3:04 p.m. Stated that officers responded to the area of 1234 Lathrop, City of Lansing, Union County, where a call from a caseworker, CMH caseworker Leanna Woods, said she had just been stabbed by her patient Beatrice Martinez. It stated she'd been sitting at the table inside the house when Martinez talking about the drug use when Martinez suddenly accused her of stealing the debit card. What stated that she stood up, showed Martinez that she was wearing the dress and didn't have pockets to hide it, as well as saying she would not do something like that. Wood said Martinez then stood up, walked in the kitchen and grabbed a red or purple knife, came back into the living room area and quickly stabbed her in the left forearm. Wood stated Martinez appeared to be in a manic state. Okay, any additional factual basis?
Nothing to the people here, thank you.
Your Honor, just to clarify that there was the injury, there was a significant injury.
Oh, yes, the victim sustained here. Woods had a laceration to her left forearm, which was treated on scene by Lansing Fire Department. However, she refused transport to the hospital, saying she might go later. I think there was a picture attached as well that shows the laceration. Was the defense satisfied with the factual basis?
Yes, Your Honor.
Okay. The court finds that a no contest plea is appropriate under the circumstances, and I will accept your plea. Found your plea to be made freely, voluntarily, and intelligently. Just want to let you know, because there is a Killebrew agreement. If it's at the time of sentencing, if I'm going to defer from that sentence agreement, if that agreement's between you and the prosecutor, I will give you an opportunity then to withdraw your plea. Okay, ma'am? Okay, and then also file number 21-02116 will be dismissed, and count 1 will be dismissed.
Your Honor, I believe I need to sign the Nolly. Mr. Bigelow prepared it, but I have not signed it yet.
No problem. This matter will be set for sentencing. And prior to sentencing, ma'am, you'll need to meet with probation so they can provide the court with the pre-sentence report and recommendation, okay?
Okay.
The sentencing is gonna be scheduled. Give me another date. I don't care if it's further or shorter, that date's just not gonna work for me. It's my mom's birthday.
May I approach, Your Honor?
Okay,
Summer 17th.
thank you. It's gonna be December 17th at 8:30, you say? At 8:30 in the morning. Are you being held on this matter only?
Yes, now that the misdemeanor case has been dismissed. Yes.
Okay. We'll get you a referral to probation. If you're still in the custody, they'll meet with you at the jail. Otherwise, you'll need to report to them within 48 hours.
Okay.
Of today's date so that you can go ahead and get that pre-sentence report scheduled and you can fill out the questionnaire that they have for you. Okay, ma'am?
Okay.
Any additional matters for the record?
Nothing for the people, thank you.
Yes, Your Honor, we would like to address bond in this case. Your Honor, bond is currently set at 50,000 cash or surety. I believe that was related to the fact that when Ms. Moya Martinez was first arrested, there were significant mental health concerns. She was evaluated. They determined that while there may be some underlying issues, the primary issue in this case was essentially the use of meth. She's been off of meth now for several months. She's been in jail for 57 days at this point. There's no longer a felony charge here. There's a killabrew to probation in this case. When I looked up her criminal history, I found that she had a retail fraud in 1999 and 3 driving with a suspended license since that time. And that is the extent of her record. So she does not have some type of assaultive history. She's lived at the same address for 20 years here in the city of Lansing. And she also informed me this morning that she's lined up a job that she could start tomorrow at the Delhi Glass Company. So based on all of that, we're asking for a PR bond at this time.
You said Delhi Glass Company?
Yes.
Okay, what are you gonna be doing there?
Answering the phone to answer questions about the products that they sell. I got 24 years of experience on the phone, inbound, outbound. I had worked in 2 years.
Thank you. Did the people want to address the bond?
Thank you, Your Honor. I will leave the matter of bond to the court's discretion, but perhaps noting, as Mr. Goodrich indicated, that a lot of the issue here stems from her drug use, and perhaps the court would be willing, if it does grant a PR bond, to add a condition of testing. And I apologize, I don't have her current bond conditions, but certainly that may be an appropriate way to help address a historical or continued drug use to have her on a testing regimen, Your Honor.
Okay, I'm looking at the K53. I don't see where there was a condition imposed at the time. Was a bond set at $50,000 cash surety. The court will grant the request to amend the bond. The bond will be amended. 5,000 personal recognizance. While out on bond, you don't have to have any contact directly or indirectly with the alleged victim. That's Leanna Woods, not to be within 1,500 feet wherever she lives, works, or goes to school. You're going to be ordered to participate in substance abuse testing. And that'll be facilitated through probation. You need to make sure you appear back in court for your sentencing date. That can be via Zoom if all parties consent.
The people would consent, Your Honor.
For your sentencing, if you want to come to the court in person.
I want to come to the court in person.
Okay, so we'll see for your sentencing date. We'll get you a copy of your notice here.
Okay.
Do you have any questions today, ma'am?
No, ma'am.
Any additional matters for the record?
Nothing for the people, thank you.
No, Your Honor, thank you.
You are for the record.
Okay. Okay, thank you.
Thank you, Your Honor.
Thank you. Have a good one. Logan Hill. Were you able to track down Mr. Carter?
I have not tracked him down, Your Honor. I called him and texted him. Like I said, we spoke last Friday. But that's the last piece.
Okay, so what we'll do is we'll have my staff send an email to see if we can track him down. He's sitting around waiting.
I have a case before Judge Ward, so I'll complete that matter and I'll check back in after that.
Sounds good. Mr. Hill?
Yes.
Okay, thank you. Let's see, Mr. Bigelow, I contact send Mr. Carter an email, tell him he's supposed to be in court with this. Yeah. Are we ready on Mr. Hill?
I believe so, Your Honor. Mr. Hill, this is Charlie Petrovich in the courtroom. We spoke yesterday, and I believe it will be a waiver of the preliminary examination.
Okay, Mr. Hill, did you need to speak privately with your attorney at all?
Yes, I have.
No, would you like another opportunity to speak privately with your attorney right now?
Oh,
Or are you ready to proceed?
we can proceed.
Okay. We're on the record in the matter of the people of the state of Michigan versus Logan Hill. File number is 21-02719 FY. Appearances, please.
Thank you, Your Honor. Aaron Husfield on behalf of the people.
And Charles Petrovich on behalf of Mr. Hill, who is present by Zoom.
Today's the date that was set for preliminary examination. I have a note here that we're waiving this matter to circuit court. Is that accurate?
Yes, Your Honor, thank you. The people would unconditionally waive their right to the holding of a preliminary examination and ask that the matter be bound over to the circuit court on the complaint as filed.
That is a full and accurate statement, Your Honor.
Was there an offer extended?
There was not, Your Honor. Negotiations may continue at circuit court.
Okay, and Mr. Hill, that's what you want to do? You want to waive your examination today?
Yes.
Okay, and you are aware that you have a constitutional right to have a preliminary examination here in the district court?
Yes.
You understand that you have the constitutional right at that examination to have prosecution establish their burden of probable cause. So they need to meet their burden that probable cause exists, that a crime was committed and probable cause to charge you with that crime. You understand that?
Yes.
You want to waive that right today?
Yes.
Has there been any promises to you to get you to waive your exam?
No.
Anybody threatening you to get you to waive your exam?
No.
I find your waiver to be made freely and voluntarily. I'll bind this matter over to the circuit court for further proceeding. Your bind over date is going to be October 27th, 2021. You do not need to appear in court on that day. That's just the date they'll get the file from the district court. Once the circuit court gets the file, they'll set your next court date, which will be a pretrial, okay?
Okay.
Are you still at the address on Highland Street?
Yes.
Okay, that'll be the address that will be provided to the circuit court. Your attorney will be made aware of your next court date, and he'll keep you abreast of that. Your number still ends in 4765.
Excuse me?
Your telephone number still ends in 4765.
No, it does not.
What's your telephone number?
517-930-7575.
Okay, that has been updated in the file. Your bond at 3,000 personal recognizance will continue. Any additional matters for the record?
Nothing for the people, Your Honor. Thank you.
And nothing for the defense. Thank you.
You're all set.
Thank you.
Mr. Hill, I'll just be in touch when I have that next court date for you. Remember, you
Okay.
do not have to do it on the 27th, but I'll let you know as soon as we have a real date for you.
Okay, thank you.
Are we running Trevino?
We are not, Your Honor. It will be a part dismissal and part waiver, if I understand Mr. Petrovich's client's position correctly.
Okay, so he's downstairs in custody, is that where?
Yes, that's
Okay.
right. I'll probably have to talk to him just briefly before starting, just to make sure he's still in line with what we talked about 2 days ago. Mr. Hill, you can sign out. We're all set with work. Oh, all right.
I'm going to assume that Holsinger is still being screened.
Well, did Mr. Goodrich responded? So Mr. Bigelow, I don't know that answer, Your Honor. What I do know is that Mr. Bigelow sent an email this morning inquiring of a status update.
Okay.
Mr. Goodrich,
I have Jared Austin on that one.
I'm sorry, then Mr. Austin,
Okay.
my apologies, Your Honor. Mr. Austin responded to Mr. Bigelow with a very detailed explanation
Oh,
that perhaps the court should just
sounds good. I'll just
Read.
have Mr. Bigelow update his file.
Thank you. Okay, well, I will be right back then, Your Honor. Thank you so much.
No problem.
Are you gonna wanna just chat with him in here?
Yeah.
You here, he'll be my spot.
On the record in the matter of the people of the state of Michigan versus Daniel Anthony Trevino, file number is 21-02466. Council appearance, please.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
And Charles Petrovich on behalf of Mr. Trevino is present to my right.
Thank you. How are you today, Mr. Trevino?
Pretty good. How about yourself?
I'm pretty good, thank you. Today's the date that's set for preliminary examination. How are we proceeding?
Thank you, Your Honor. At this time, the people will move to dismiss count 1, assault with a dangerous weapon, felonious assault, and will unconditionally waive their right to conduct a preliminary examination and ask that count 2 be bound over to the circuit court as listed on the complaint.
Okay, Mr. Petrovich?
That is a full and accurate statement, Your Honor. Mr. Trevino is prepared to waive preliminary examination with regards to count 2 today.
And Mr. Trevino, you understand that you have a constitutional right to have a preliminary examination here in the district court?
Yes, Your Honor.
I understand that at the time of examination, you have the right to have the prosecution establish their burden of probable cause. So they have to establish probable cause that a crime was committed and probable cause to charge you with that crime. You understand that?
Yes, Your Honor.
Are you willing to waive your examination today unconditionally?
Yes, Your Honor.
Okay, so that means you can't come back later and say you want your exam. You understand that?
Yes, Your Honor.
Has there been any promises made to you to get you to waive your exam?
No, Your Honor.
Any threats being made to you to get you to waive your exam?
No, Your Honor.
Has there been an offer extended at all?
There has not, Your Honor.
Okay, I find your waiver to be made freely and voluntarily. I'll bind the matter over to the circuit court. For further proceeding, your court dates will be set by the circuit court after bind over date. Your bind over date is going to be October 27, 2021. You don't need to appear in court on that date, okay? That's just the date they're getting the file from this court. Mr. Petrovich will be notified of your pretrial in circuit court, okay?
Yes, Your Honor.
Are you being held on something other than this?
He is, Your Honor.
Okay. Count 1 will be dismissed and bind over will be as to count 2. The current bond is set, it says. It says in the file 1,500 in cash, but that doesn't make sense. Okay, cash sureties, leave the bond. What does it say in the JIS?
Yeah, it says the 15.
1,500,
10%.
10%, okay. This is 10%?
Mhm.
Okay, so it should be 1,500, 10% bond. And bond will continue. Any additional matters for the record?
Nothing for the people. Thank you, Your Honor.
And not for the defense. Thank you.
Thank you, you're all set.
Thank you, Your Honor. Enjoy the rest of your afternoon.
Same to you.